clause on Bill C7. Just a quick housekeeping for all members. When you're speaking, please speak slowly and clearly. Unmute yourself before you speak. To allow for interpretation, do speak slowly and clearly. And if you're not speaking, please keep your microphone on mute so that we're not disrupting other members. And so we do have the department officials here with us today, the Department of Justice and Department of Health. They are having some IT issues, which we're trying to resolve with their connectivity. But I believe that as that's getting resolved, we can continue. We left off with CPC 8 yesterday, and that is where we will pick up again today. And just so members are aware, there was an amended notice of meeting that was sent out today with a clarified agenda of today's plan. Hopefully we're okay with that. And so I will start with resuming debate on CPC 8 at this time. I see no members' hands raised, so we'll just call the question on CPC 8. Mr. Clerk, if you can please record the division. Thank you.
Okay. Mr. Cooper?
In support of the amendment.
Ms. Finlay?
I support the amendment.
Monsieur Thériault?
Je suis contre.
I'm against the amendment.
Mr. Garrison?
For the amendment.
Mr. Kellaway?
Opposed?
Mr. Lewis?
I vote in support of the amendment.
Mr. Maloney?
Against.
Mr. Moore?
I support the amendment.
Mr. Sangha?
Against.
Mr. Virani?
Against?
Et puis Madame Brière?
Against. Contre.
Against.
So, Madam Chair, yes pour 4, 4, et nays contre 7, 7.
Thank you, Mr. Clerk. So CPC 8 is then defeated. We're now moving on to CPC 9. Mr. Moore, I do have concerns about the admissibility of CPC 9. So as you're moving the amendment, can you please speak also to its admissibility as well as the reasons behind it? Thank you. Go ahead, Mr. Moore.
Thank you, Madam Chair. And I would like to move CPC 9, which amends Bill C7, amends Section 241, which Bill C7 does touch on. So I think this is fully within order. But we heard testimony at committee, which I thought was a very important testimony from, for example, Roger Foley. And as you know, Roger Foley, and for anyone who doesn't know, you can certainly find his story on media, where various media outlets reported that Mr. Foley had been, it appears to be, had been feeling some pressure to consider MAID, and he in fact made recordings to this effect. So this is very important because we're in a new stage now. Under Bill C-14, introduced by this government, an individual had to be their death had to be reasonably foreseeable. Now, that was never defined, and we chose not to define it as a committee. But reasonably foreseeable now, death is no longer a requirement to provide for assisted death. So, in effect, someone does not have to be dying to be eligible for assisted dying. So I want to, specifically on this amendment, I want to mention from the Canadian Society of Palliative Care Physicians. They speak directly to this. They sent us a submission on Bill C7, and their fourth recommendation is a recommendation on bringing up assisted dying. And to safeguard against any possibility of subtle or overt pressure on patients, healthcare professionals should not initiate a discussion about MAID or suggest the option of MAID unless brought up by the patient. If a patient raises questions or requests MAID, healthcare professionals should have the ability to explore these issues, including their underlying suffering, provide information, or direct them to someone who can provide information. In other jurisdictions, I draw the committee's attention to this, in other jurisdictions where assisted dying is legalized, such as in the recent legislation in Victoria, Australia, this risk of coercion due to the hierarchy and differential of expertise present in the physician-patient relationship is addressed directly in the law. Victorian legislation states that a healthcare practitioner must not initiate a discussion or suggest voluntary assisted dying to a patient. So the palliative care physicians go on to say, we urge the federal government to reduce harm of coercion to vulnerable patients by including this in the current revisions to the current MAID legislation. We also received a submission from the persons with disability community. They make a number of recommendations. Their fourth recommendation as well is investigate the worrisome claims about persons with disabilities in institutions being pressured to seek MAID and practitioners not formally reporting cases involving persons with disabilities, which were identified in the UN Special Rapporteur's report, and establish an independent body whose membership must include representatives of the disability community to investigate such cases moving forward. So we Conservative Party members listened to the testimony of those witnesses. I paid particular attention to the testimony of Roger Foley, and that is why we're moving CPC Amendment 9 that deals directly with the issue of when medical assistance in dying should be brought up. And it makes it crystal clear that this should be a patient-initiated discussion, not a physician-initiated discussion. Thank you, Madam Chair.
Thank you, Mr. Moore. I will have to rule CPC 9. So Bill C7 amends the criminal code in relation to MAID. The amendment here, CPC 9, seeks to create a new criminal code infraction of coercing someone to request MAID, which would amount to counseling or aiding a person to commit suicide under Section 241 of the Criminal Code. Since Bill C7 only provides for an easier access to MAID, the amendment goes beyond the scope of the bill. As the House of Commons Procedure and Practice 3rd edition states at page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. Therefore, as stated before, I rule that this amendment is inadmissible and it goes beyond the scope of this bill. So with that, we will now call the question on Clause 1. As we have completed discussion and debate on all of the proposed amendments for Clause 1.
Point of order, Madam Chair.
Yes, Mr. Moore?
Madam Chair, while I respect your ruling, I do feel that Bill CPC 9 is within the scope of this legislation. It deals directly with the provision of assisted dying. It deals with the very things that this bill deals with, and it's an important safeguard. And for that reason, I'd like to challenge the ruling of the chair on admissibility of CPC 9.
Thank you, Mr. Moore. So we'll call the question, should the chair's ruling be sustained? So go ahead, Mr. Clark.
You know all this by heart now.
What?
Yeah. Okay. Wow. Mr. Cooper.
No, the ruling should not be sustained.
Miss. Miss Findlay?
I can't hear the clerk. His voice is going in and out for me.
Miss Findlay, I called you. I
There
called
you-
your name.
There you are.
Yes.
There you are. No, I don't agree with the ruling.
Monsieur Thériault?
Je suis pour le maintien.
Mr. Garrison?
I vote to sustain the chair.
Mr. Calloway?
Yes.
Mr. Lewis?
I vote against the ruling.
Mr. Maloney?
Vote yes.
Mr. Moore?
I vote no.
Mr. Sangha?
Yes.
Mr. Virani?
Vote yes to sustain the ruling.
Et puis Madame Brière?
I sustain the chair.
Donc, yeas pour 7, 7, et nays contre 4, 4.
Thank you, Mr. Clerk. So my ruling is sustained.
Point of order.
Yes, Mr. Moore?
Thank you, Madam Chair. Before we move on to the vote on CPC 9, on CPC 8, it was brought to my attention, I thought I heard it as well, that 4 people voted in favor when I think it was 5 that voted in favor of CPC 8. I just want to make sure the record is accurate.
You are right, Mr. Moore, so the record will be corrected. Thank you for pointing that out. And just also to clarify, Mr. Moore, we're not voting on CPC 9. We're now voting on Clause 1, should Clause 1 as amended carry. So, Mr. Clerk, if you can administer that vote, please.
Miss Findlay with her hand raised?
Oh, it's been raised for a while.
Oh, okay. Mr. Cooper?
No.
Miss Findlay?
No.
Monsieur Thériault?
Oui.
Mr. Garrison?
Yes.
Mr. Calloway?
Oui.
Mr. Lewis?
No.
Mr. Maloney?
Yes.
Mr. Moore?
No.
Mr. Sangha?
Yes.
Mr. Virani?
Yes.
Puis Madame Brière.
Oui.
Donc, yeas pour 7, 7, et nays contre 4, 4.
Thank you.
Merci, Monsieur le greffier. La clause 1 est adoptée. Nous n'avons pas reçu de modification pour la deuxième clause, alors vous rappel au règlement, Madame la Présidente. Oui, Madame Findlay. Je ne peux pas entendre ce que dit.
Terio's mute is not on. And there it is. It's on now. So I didn't hear anything you just said. Sorry.
That's absolutely fine, Madame Findlay. I'm happy to repeat myself. So Clause 1 as amended carries. Now, because there were no amendments submitted for Clause 2, I'll call the question on Clause 2. Mr. Clerk, if you can please record the vote. Shall Clause 2 carry?
Mr. Cooper?
No.
Miss Findlay?
No.
Monsieur Thériault?
Oui.
Mr. Garrison?
Yes.
Mr. Calloway?
Oui.
Mr. Lewis?
No.
Mr. Maloney?
Yes.
Mr. Moore?
No.
Mr. Sangha?
Yes.
Mr. Virani?
Yes.
Madame Brière?
Oui.
Yeas pour 7, 7, nays contre 4, 4.
Thank you, Mr. Clerk. So Clause 2 does carry with that vote. Now moving on to Clause 3 and the proposed amendments before us for Clause 3, we have PV 3. I'm not sure if Mr. Manley is here to speak to. Oh, okay. We'll just give a couple of seconds to Mr. Manley. I see that he's joined us now by video conference. Mr. Manley, if you'd like to briefly speak to PV3, please go ahead.
Well, thank you, Madam Chair. This amendment is another amendment that was adopted from a request by Inclusion Canada and supported by the Nanaimo Association for Community Living. And this is about collecting relevant data on the people who received MAID and will help with research so we have a better understanding of the circumstances of the people who have accessed MAID. This includes information regarding the factors in the living conditions or life circumstances of a person who has requested medical assistance in dying that may be causing or increasing their suffering, and any services or care that has been offered or made available to them, including palliative care, disability supports, assistive technology, income assistance, counseling services, communication supports, and environmental accommodations. And any regulations must provide for the establishment of data collection system designed to facilitate the analysis and interpretation of information provided, particularly as it relates to the protection of vulnerable persons from being induced to end their lives. So this is really about not putting barriers in the way of MAID, but understanding what are the factors involved in people accessing MAID and ensuring that we have proper data collection for researchers and people interested in following up on why people have accessed MAID. Thank you.
Thank you, Mr. Manley. Mr. Virani, I have you next. Go ahead, sir.
Thank you very much, Madam Chair, and I thank Mr. Manley for his continued participation in this committee hearings and in this clause-by-clause analysis. I'm going to be opposing this amendment. I think there's no objections to the objective that's being pursued, presenting a comprehensive picture on how medical assistance in dying is being delivered in Canada is important. It's important for monitoring to occur to collect a range of information, but I believe that the amendments that are being proposed are actually not needed. The first part of the amendment is not needed insofar as if Bill C7 is enacted, the regulations will be amended to align with the legislation, resulting in the collection and analysis of additional data. In developing those regulations, government is going to consult with a broad range of stakeholders, including the groups representing persons who may be vulnerable. The second part of the amendment, in my respectful view, is also not necessary, as the federal monitoring system is already designed to analyze and report on available data regarding the protection of persons. I can give you an example of this, Madam Chair, for the benefit of the committee. The practitioner reports on how they determined the request for medical assistance in dying was voluntary. This data is reported in an annual report. So on that basis, although I agree with the spirit of what the amendment is driving at, I do not think it is necessary, and will be voting against it. Thank you.
Thank you, Mr. Virani. I have Madame Finley next on the list. Go ahead, Madame.
Thank you, Madam Chair. I would like to speak in support of this amendment, and I thank Mr. Manley for bringing it forward. To me, it simply isn't the same, and in practice, I think if one reflects, others may agree with me, it's not the same to have implementation in regulations as having it in as a requirement in legislation. The whole point of this amendment, as I read it, is to make sure this is being done. Right now, we're going through this bill, but we already know that we will be going through a study which should have been commenced in June and wasn't because of prorogation. And we're here dealing with a bill in many ways where we don't have sufficient data. We're bringing data, the data is inconsistent between provinces. There's certain data coming from some provinces, no data from others. To my mind, that's partly because there is not a requirement within the legislation that this data be collected. This would be very informative. Here we're dealing with a bill which 4 years ago looked very different when it was first passed. Now this is a revision of an earlier piece of legislation, and we're doing it without sufficient data, in my view. This would be very helpful. If you look at the specifics of this amendment, it speaks exactly to who is choosing this, why they may be choosing this, what resources were available to them, how this came about. It's exactly the sort of thing that we should be looking at in a review now and any review in the future. That next review is going to be very important. There's already signaling by the Liberal government that in that review they intend to pursue an expansion from where we are now. And it seems to me pretty basic that we should have the kind of data spoken to in this amendment to have a fulsome discussion and really understand what we're talking about and what the real lived experience is of those who have decided to access this, as well as those who decided to access it and then perhaps change their mind at some point, because we've heard that that happens as well. So I'm in support of this amendment, and I thank Mr. Manley for bringing it forward.
Thank you, Madame Findlay. I have Mr. Lewis next on that list. Go ahead, sir.
Well, thank you, Madam Chair. I appreciate the opportunity to speak, and I also echo the comments of Ms. Findlay. I want to thank Mr. Manley for his foresight to this and to bring this forward. I think it's a fantastic amendment. I would suggest, Madam Chair, that this should not be partisan in nature at all. And I hope that we can count on our colleagues across the floor, so to speak, to really support this, because I believe it's an amendment that is about human dignity and compassion. It is about ensuring that we can figure out where supports are lacking for disabled people and why they chose to end their lives prematurely, so that we can do everything in our power to help them live a dignified and full life, having received the support that they require. Madam Chair, this morning there was a press conference, and I jumped on to watch it, and there was some, I'm not going to call it testimony because it didn't come to this committee specifically, but there was some very, very powerful speakers this morning from the disability community, for a lack of better words. I apologize. But there was some fantastic testimony, and there was so many things that really hit home for me. And I believe that this amendment, the clause 3, I guess you would, Green Amendment 3, really brings home what they're asking for and protects their rights specifically. And so again, to Mr. Manley, I want to say thank you very much for bringing this forward. I'll be voting in favor of this. Thank you, Madam Chair.
Thank you, Mr. Lewis, for that. Mr. Moore, go ahead, sir.
Well, thank you, Madam Chair. And, you know, I think some of the most important testimony we heard in the very limited testimony time that was allotted at this committee, only 4 days, and one of those days was the ministers responsible. So really only 3 days of testimony. And one of the most important takeaways from the testimony that I heard, and we heard from physicians, from psychiatrists, from MAID practitioners, but I think some of the most important testimony came from those representing the persons with disability community. And Mr. Manley mentioned that this particular amendment is supported by Inclusion Canada. Inclusion Canada is a organization that represents the interest of persons living with disabilities, but the persons living with disabilities community, there's provincial organizations, local organizations, national organizations. They're virtually universally opposed to Bill C-7. So realizing that the numbers are against them, they want to at least make the appeal for safeguards. And there's a report prepared by Advisors to the Vulnerable Person Standard. And these are doctors, physicians that working in the Canadian healthcare system. It's titled Failing People with Disabilities Who Experience Systemic Suffering, Gaps in the Monitoring System for Medical Assistance in Dying. Certainly recommended to all committee members. But they make the case. They say that the existing monitoring reporting system is the result of a federal-provincial negotiation. At the time it was first developed in 2018, comprehensive proposals for a more robust system were put on the table by a broad cross-section of experts and disability organizations. However, these were rejected by the federal government. And they're saying, and they go on to list a number of situations, cases where they've identified gaps in the monitoring and reporting system. Several cases of people with disabilities who requested and received MAID raised very serious concerns that the eligibility criteria for access are not being adhered to in all cases, nor is the process for obtaining informed consent and guarding against external pressure as the legislation requires, always being managed in a way to fully explore alternative courses of action. In some cases, it appears that multiple pleas for access to needed supports have gone unaddressed, eventually leading the person to give up and apply for and accept MAID in apparent defeat. They mentioned the case of Archie Rowland, who was transferred against his will from a residence that provided highly specialized care to a geriatric long-term care facility in Lachine, Quebec. Without staff adequately trained to communicate with him and provide essential care, he spent the remaining days of his life documenting the suffering that this caused and advocating for humane and capable care. And I think, how inspiring is it that some individuals that are dealing with a really low point in their life, and all of us saw the testimony of Roger Foley, who they're, in spite of the challenges they're facing, they take the opportunity to try to advocate on behalf of people who may walk down the road that they're traveling. And I find that inspiring that they do that. And one of the things that these groups, the Persons with Disabilities organizations, Inclusion Canada, they're saying that there needs to be more robust safeguards, and they support this amendment. And with that, Madam Chair, I'd like to indicate my support as well for this amendment, Green Amendment 3. Thank you.
Thank you, Mr. Moore. I don't see any more hands raised, so I'll call the question on PV3 at this time. So go ahead, Mr. Clerk.
Mr. Cooper?
In support.
Ms. Finley?
I support this amendment.
Monsieur Thériault?
Je suis contre.
Mr. Garrison?
Against.
Mr. Calloway?
Against.
Mr. Lewis?
I support.
Mr. Maloney?
Against.
Mr. Moore?
Support.
Mr. Sangha?
Against.
Mr. Virani?
Against.
Madame Brière?
Contre.
On yeas pour 4, 4, nays contre 7, 7.
Thank you, Mr. Clerk. So PV3 is defeated. We'll now move on to PV4. And before I ask Mr. Manley to comment briefly on PV4, I will refer members to an email received yesterday on some friendly amendments that were circulated. So Mr. Manley, if you can also speak to those as we initiate debate on PV4. Go ahead, sir.
Well, thank you, Madam Chair, and I appreciate the friendly amendment on this this amendment, and I accept it. So I'm hoping that people will support this amendment. Given the clear objectives stated in the preamble related to protecting the human rights and inclusion of people with disabilities in respect of the Charter and the UN Convention on the Rights of Persons with Disability, the minister responsible for the status of persons with disabilities in the Office of Disability Issues should be mandated to share in the responsibility for monitoring and reporting to Parliament on the MAID system. So this motion just simply states in performing his or her function or duties under subsection 3, the Minister of Health should consult with the minister responsible for the status of persons with disabilities. And again, this is an amendment that was adapted from information sent to me by the Nanaimo Association for Community Living Executive Director Graham Morey, and information from Inclusion Canada and Inclusion BC. So I hope people will support this amendment. Thank you.
Thank you, Mr. Manley. Mr. Virani, go ahead, sir.
Thank you very much. And again, I thank Mr. Manley for his contributions to this legislation and to this clause by clause discussion. So it is this is a very helpful idea that's being proposed, and the nature of what I was suggested as the friendly amendment that Mr. Manley is content with is circumscribing it a little bit. So part of my amendment actually removes the language that relates to the Office for Disability Issues. I'm advised that that office is not a legal entity and that the title and the name of that office may change over time. So entrenching it in a statute is not advisable. And secondly is the language with respect to the nature of what the Minister of Health is required to do. In my view, I thought the language should look like something like should consult, as opposed to must, when appropriate, consult. I've had over the last 48 hours some back and forth with different people about which language is actually most appropriate for an amendment that is actually amending the criminal code. So I'm actually going to actually ask the department to weigh in on whether should consult is appropriate or whether must, comma, when appropriate, comma, consult is appropriate language for the purposes of coherence of the criminal code. So over to the department officials who have been patient for many, many hours during the course of this clause by clause. And I thank them for their patience.
Thank you, Madam Chair. We did take a look at and consider this language, and we had some discussions with the legislative drafters at the Department of Justice. We were unable to locate a provision in the federal statute book that talked about that a minister should do something. It's our collective view that the law directs what must be done, or the law can permit what otherwise might not be permissible, but the law does not generally make a recommendation, because the law is there to be enforced when it's not followed, and it's not evident how you could enforce something that was just a recommendation about something that a minister should do. So I think the view of the Department of Justice is that it would be more appropriate and in keeping with the way ministerial consultations and other obligations on ministers are crafted, that it be must, when appropriate, consult.
Thank you very much for that, Ms. Kleinberg. We'll go to Mr. Maloney. You have your hand raised, sir. Go ahead.
Thank you, Madam Chair, and thank you for that clarification. In light of that, I would propose that we use the word must in the amended language that's contained in the November 24th email. If that requires a motion, Madam Chair, consider it so moved.
Point of clarification, Madam Chair.
Yes, Madam Findlay.
Is Mr. Maloney suggesting just the word must, or must when appropriate?
Thanks for that, Madam Findlay. And I was actually going to seek the same clarification from Mr. Maloney. If you can just clarify the exact language, sir. Go ahead.
Thank you, and I appreciate that, Ms. Findlay, and for pointing that out for me. I believe it should be must when appropriate.
Thank you.
Thanks, Mr. Maloney. Mr. Virani, go ahead, sir.
So just so that I'm crystal clear, so we've heard from the officials. I support, I think, what Mr. Maloney is suggesting. So the language would be pursuant to my November 23rd, to the email sent out by the clerk on November 23rd at 1:26 p.m., tracking that exact language, but instead of the words should consult, it would say must, comma, where appropriate, comma, consult. And other than that, the language is intact in that email. So that's what we are voting on now.
And again, just a point of clarification, I want to make sure what I'm voting on is the word consult or collaborate.
The language was consult in terms of. Yes.
All right, thank you.
So thank you, both Mr. Virani and Madame Findlay. I'll just turn to our legislative clerk just to clarify on the exact language that's before us right now.
Thank you, Madam Chair. The question is more directed to the Department of Justice officials. So if you allow me, I'm just going to read the English version first, and then see what the French version might be. So the English version would read, paragraph 6, in performing his or her function or duties under subsection 3, the Minister of Health must, when appropriate, consult with the minister responsible for the status of person with disabilities. Is that correct?
Yes, as I understand it, yes.
Mr. Maloney, if you can just confirm.
Yes, that's that. Thank you, Madam Chair.
Thank you. Go ahead, Mr.
And now for the French version, if you have one, I would read dans l'exercice de.
So, in carrying out their responsibilities under paragraph 3.
Est-ce que vous m'entendez, Monsieur Thériault?
Can you hear me, Mr. Thériault? Yes, I can hear you now. Sorry, I'll start again. So, in the French version of the amendment in question, paragraph 6, in carrying out their responsibilities under paragraph 3, the Minister of Health consult when required with the minister responsible for the status of persons with disabilities. Is that the version that you subscribe to? No, not exactly. Not exactly. What I heard from my colleagues in drafting was Pluto, in carrying out their responsibilities under paragraph 3, the Minister of Health shall consult when appropriate the minister responsible for the status of persons with disabilities.
Est-ce que cela est indiqué avec le ministre?
So you said when it is appropriate with the minister responsible. Is that correct? No, just drop the word with, please. The word avec in French. So the Minister of Health shall consult, when appropriate, the minister responsible for the status of persons with disabilities. Thank you. That's perfect. Thank you very much.
Thank you. I have Mr. Virani next on the list. Go ahead, sir.
I'm sorry. I'm perfectly happy with the language in français and in English that we've just heard. And my hand was just left over being raised. I apologize.
Thank you, Mr. Virani. Mr. Moore, go ahead, sir.
Yes, thank you, Madam Chair. You know, we just heard from the department lawyers about having certainty because we're dealing with criminal code provisions and the concern around should, because who determines what should is? So now we're saying must, but then we're adding in the kind of wiggle room when appropriate. So the same people that would be determining should are now determining when appropriate. So who decides when appropriate? Who decides should? So I think we're completely back at square one with this. And I would propose, I don't know what we're concerned with here, to just say that the minister must consult. Leave out the when appropriate, because it leaves this open to uncertainty, and we can't have that, I don't believe, when we're dealing with something this serious and when we're dealing with provisions that are dealing with assisted dying. who's going to make that determination? So the same person that would be making the determination of whether they should consult is now going to be making the determination of, well, they must consult, but when appropriate. So in my mind, there's no difference between those two things. I'm sure, to me, it'd be a lot more certain, clear, and we'd be doing everyone a great service to just say that the minister must consult.
Mr. Moore, just procedurally, first we need to vote on the amendments that are before us before you can further amend. So I will come back to you if you would at a later time once we voted on these sub-amendments to propose any further amendments. I have Mr. Cooper next on my list, and then Monsieur Thériault. Go ahead, Mr. Cooper.
Thank you, Madam Chair, and I really was going to say what Mr. Moore already said, but it would seem to me that the wording as presently drafted, as opposed to should or must where appropriate, provides much greater clarity and certainty. And on the question of enforcement, I guess no matter how you look at it, whether the minister must consult, whether the minister should consult, whether the minister must, when appropriate, consult, I don't know if, from an enforceability standpoint, that any of those versions changes that question. But what this would do is very simply provide a positive duty on the part of the minister to consult, and I think that duty is essential, having regard for the very, very serious concerns that have been raised by the disabilities rights community. So on that basis, I would support the existing language.
Sorry, Madam Finley, I'm just going to clarify something Mr. Cooper has said. The existing language does say must when appropriate.
Sorry, not just to clarify, the language that before it had been changed, where that simply provides the original amendment provided for must. That's the original amendment. And so that's the language that I support.
Thank you, Mr. Cooper. Madame Finley, you had a point of clarification?
Yeah, please. I would like to hear from the department officials what the difference is in terms of enforcement or interpretation between must and must when appropriate. Because I don't think I've seen language like when appropriate in the criminal code. I certainly understand the word must. Could we just hear from department officials on that, please?
Go ahead, Ms. Kleinberg.
Thank you, Madam Chair. I don't think that this is an issue that is specific to the criminal code as opposed to other statutes. The criminal code does not have very many regulation-making powers for ministers in it, which would be a place where there might be duties to consult. So I think these issues are just more general legislative issues. And I think the difference between must consult and must when appropriate consult is simply that the latter version, with the addition of the words when appropriate, means in relation to the aspects of whatever it is the minister is doing, where that consultation would be necessary. So the MAID monitoring regulations, for instance, they will contain aspects that perhaps are completely unrelated to the issues that the minister responsible for the status of persons with disabilities would be interested in. So they might relate to, for instance, developing, and this is just a hypothetical, but regulatory obligations on the practitioners to provide information about their area of specialty that they practice in. That may not be something where input from the minister responsible for the status of persons with disabilities would be pertinent. So I think all that the when appropriate does is say that when there is the aspect of the regulations that the Minister of Health is working on, when they are directly or indirectly related to the responsibilities of the other minister, that is when the obligations would be required, the obligation to consult.
Thank you. Does that clarify for you, Madame Finlay?
Yes, it does.
Thank you.
It does
So-
clarify, but I had another point of clarification. I thought it was possible to sub-amend an amendment. It seems rather too late for a sub-amendment if we've already voted on an amendment. So if Mr. Moore is suggesting a sub-amendment, to me, I thought that would be an appropriate thing to do. From the floor.
Yes, Madam Finlay. We have the amendment from Mr. Virani that was sent on the 23rd of November.
Right.
So that's the main.
And then Mr. Moore was just now suggesting a sub-amendment to take out the words "when appropriate" from that suggested amendment.
Sorry, but there was.
Is that not possible?
No, because there is another sub-amendment already on the floor to change the wording "should" for "must" when appropriate. So this one has to be dealt with first. And then after that, if this one is defeated, Mr. Moore could move his to simply put "must" instead of what's there at the moment.
Thank you. I will go to Monsieur Thériault now. Go ahead, sir.
Well, my comments are directed at the department's lawyers. In the criminal code, is it common that this kind of provision would be included, where it is required that a minister, or where the relationship between departments or ministers are such that they must consult other departments and ministers, and I'm talking federally speaking, of course. Does that create an obligation on the part of the territories and the province of Quebec, for example, to have their ministers or their counterparts? Does that obligate them? So what would be the relevance of that article in the criminal code per se?
Merci, Madame la Présidente.
Thank you, Madam Chair. Well, as I mentioned a couple of minutes ago, I don't believe that it's a question of law. In this case, it's rare in the criminal code that there be obligations that would create regulations governing ministers, but that does happen in has happened in a couple of cases. But what I've understood from my colleagues in drafting, the ministers are obligated to create regulations when it comes to consulting with other ministers. Well, yes, that is quite common. And they are able to provide a number of examples of ministers who are obligated to consult their counterparts. But I'm not personally aware of any others in the criminal code, per se. That said, I don't think that would impugn on the validity of such a obligation, whether it be in the criminal code or elsewhere. Now, I don't see how it would impact on provincial ministers in any way. I think to have an impact on provincial ministers, there would be a need for more explicit language. Follow-up question. So a minister who was told, for example, that it is appropriate to consult but that the minister who hasn't consulted, would that minister be in hot water in some way or another? Would he be put in a bit of an awkward position, or she in an awkward position, if in the criminal code that kind of collaborative relationship was made obligatory? Does that occur, that kind of situation? Response. Well, that's a really good question you've just asked. And that's the kind of question we sometimes ask in terms of Parliament's obligations with respect to parliamentary review. Now, in the specifically related to this amendment, it doesn't have to do with a criminal code offence. The Health Minister's obligation to regulate on the monitoring system, it also is not tied in any way to any offence in the criminal code. So it's an interesting philosophical question you've asked, but I'm not quite sure that I have such a straightforward response to give to you right off the bat, unfortunately, Mr. Thériault. But that said, we could get back to you with more ample information. Response? Well, thank you. Those were just a couple of questions that were front of mind. My colleagues' arguments and points didn't really alleviate my concerns or respond to my particular misgivings vis-a-vis this appropriateness of this kind of provision in the criminal code. So I just don't see how or what it adds, but I just wanted to know if doing so would add an additional layer of constraints and obligations that might not be appropriate. Thank you very much.
Thank you, Monsieur Thériault. So I see no further discussion. I'll call the vote on the sub-amendment as read into the record by the legislative clerk and as proposed by Mr. Maloney. Mr. Clerk, if you can please record the vote.
Mr. Cooper?
Madame la Présidente, est-ce qu'on peut...
Madam Chair, could we just read it one more time, please? Given that we don't have the text in front of us, and since we are just doing this on the fly, more or less.
Absolutely. Please go ahead, sir.
Okay, I'll start with the English version. So paragraph 6, in performing his or her function or duties under subsection 3, the Minister of Health must, when appropriate, consult with the minister responsible for the status of person with disabilities. Et maintenant la version française.
And now the French version, paragraph 6. In carrying out their responsibilities under subsection 3, the Minister of Health must consult, when appropriate, the minister responsible for the status of persons with disabilities.
Voilà.
There you have it.
Thank you very much. Go ahead, Mr. Clerk.
I'm against the sub-amendment.
Ms. Finley? Ms. Finley?
There you are. I support the sub-amendment.
You support the sub-amendment?
Yes, I do.
Monsieur Thériault?
Oui, je supporte.
Mr. Garrison?
Yes.
Mr. Calloway?
Yes.
Mr. Lewis?
I vote against the sub-amendment.
Mr. Maloney?
Yes.
Mr. Moore? Mr. Moore?
Support.
Mr. Sangha?
Support.
Mr. Virani?
Support.
Madame Briard?
Oh.
OK, so yeas pour 9, 9, et nays contre 2, 2.
Thank you. So the sub-amendment carries. So, Mr. Moore, I see your hand raised on on PV4 as amended. Go ahead, sir.
Yes, thank you, Madam Chair, and thank you for the advice of the department officials as well as the clerk in this regard. And now that this particular sub-amendment has been adopted, I would like to move an amendment that deletes the words "when appropriate." For all the reasons that we heard, I won't ask them to repeat it, but justice officials say that we would not normally in the criminal code see the word "should." I do not believe that we should see a "when appropriate," because we don't tell someone to obey the speed limit when appropriate, or to not rob a bank when appropriate. So the criminal code or regulatory principles, we would not inject certainty into these clauses that we're dealing with if we're going to include the word "when appropriate," because as I mentioned before, the same person that would be determining whether they should or shouldn't do something would be the same individual or group of individuals determining whether something is inappropriate or appropriate. So I don't know if you call it a sub amendment, but my amendment to this amendment is to remove the words "when appropriate." Thank you, Madam Chair.
Thank you, Mr. Moore. So it would be still called a sub-amendment to the amended PV4. Madam Finley, I see that your hand is raised. Go ahead.
Just to speak to this, is this the time? To speak to this?
Yes, absolutely. Go ahead.
Okay, thank you. Well, basically, as I understand the wording now, it would be in English, in performing his or her functions or duties under this section, the Minister of Health must, when appropriate, consult with the minister responsible for the status of persons with disabilities. So taking out when appropriate leaves it as must. It is in the carrying out of their duties. So we're not fettering their discretion, really. We're not constricting the exercise of their ministerial duties. We're saying in the course of those duties, as you perform those duties, that they must consult with those who have the responsibility of thinking about, determining policy about, and handling the issues surrounding persons with disabilities. We've heard from this community loud and clear in this committee. There are many more who wanted to speak. I wear a pin today that is in commemoration of the fact that it's Indigenous Persons with Disabilities Month, a group we didn't really hear from. Although we heard from persons with disabilities organizations on a grander scale. So I really think that this is something that should be done. It seems very appropriate. I think we're all, in terms of the spirit of this, on the same page. It's cleaner, it's neater, more succinct, as Mr. Virani is in favor of, and generally, and that these are two ministers that should be consulting on these issues. So taking out "when appropriate," I think makes a lot of sense, and I would urge others to support this. Thank you.
Thank you, Madam Finley. And just before I call the question, I'll just turn to the legislative clerk to just read the language of the sub-amendment.
The whole clause. Thank you, Madam Chair. So the amendment with the new sub-amendment would read as follows. Paragraph 6, in performing his or her function or duties under subsection 3, the Minister of Health must, consult with the minister responsible for the status of person with disabilities. Maintenant en français.
And now in French, paragraph 6, in performing his or her functions or duties under subsection 3. I'm sorry, but I can't hear. Your microphone is not close enough. Can you hear me a bit better now? Can you hear me a little bit better now? Perfect. So I'll pick up where I left off, or I'll repeat actually. So in subsection, or rather in paragraph 6, in performing his or her functions or duties, under subsection 3, the Minister of Health must consult with the minister responsible for the status of persons with disabilities.
Thank you. So the question now is on the sub-amendment. Mr. Clerk, if you can please record the vote.
D'accord.
Agreed.
In support.
Ms. Finlay?
I support.
Monsieur Thériault?
For.
Mr. Garrison?
Against.
Mr. Calloway?
Against.
Mr. Lewis?
I support.
Mr. Maloney?
Against.
Mr. Moore?
Support.
Mr. Sanga?
Against.
Mr. Virani?
Against.
Et puis Madame Brière?
Contre.
Contre?
Contre.
OK. Alors, yes pour 5, 5, et nays contre 6.
So the sub-amendment is defeated. So we will now call the question on PV4 as amended. Mr. Clerk, if you can go ahead.
Mr. Cooper?
In support.
Ms. Finlay?
In support.
Monsieur Thériault?
En faveur.
Mr. Garrison?
Favor.
Mr. Calloway?
Yes.
Mr. Lewis?
I support.
Mr. Maloney?
Yes.
Mr. Moore?
Yes.
Mr. Sanga?
Against.
Mr. Virani?
I support.
Madame Brière?
Pour.
Yeas pour 10, 10. Nays contre 1.
Thank you, Mr. Clerk. So PV4 as amended carries. So now the question is on Clause 3 as amended. So shall Clause 3 as amended carry?
Mr. Cooper?
Against.
Ms. Finlay?
Against.
Monsieur Thériault?
For.
Mr. Garrison?
In favor.
Mr. Calloway?
In favor.
Mr. Lewis?
I vote against.
Mr. Maloney?
In favor.
Mr. Moore?
Against.
Mr. Sanga?
In favor.
Mr. Virani?
In favor.
Madame Brière?
In favor. Pour.
Yeas pour 7, et nays contre 4.
Thank you, Mr. Clerk. So Clause 3 as amended carries. Now, moving on with clause by clause, I will remind members that in our first meeting of clause by clause, I had made a ruling on CPC 1, which was sustained. Now, and at that time, I had advised members that CPC 10, being consequential to CPC 1, was also inadmissible. So just letting members know that that ruling still stands because we we had voted and that ruling was sustained. So I call the question now on Clause 4.
Point of order.
Yes, Mr. Moore?
Madam Chair, on CPC 10, which deals with conscience rights for physicians, and that's something that was brought up by a number of doctors with a number of specialties, including palliative care doctors. They've specifically recommended that we provide meaningful conscience protection for healthcare professionals with respect to MAID. While I respect your ruling on CPC 10, I would like to challenge that ruling because I believe that CPC 10 is admissible.
Thank you, Mr. Moore. We've already had that challenge on my ruling, which I had done at the first meeting of clause by clause. And so you can't challenge what was already voted on and sustained by committee members. So that would be out of order. So we'll go back to clause 4, and I'll call the question on clause 4. Shall clause 4 carry? Mr. Clerk?
Mr. Cooper?
Against.
Ms. Finley?
Against.
Monsieur Thériault?
For.
Mr. Garrison?
Favor.
Mr. Kellaway?
In favor?
Mr. Lewis?
I vote against.
Mr. Maloney?
I vote yes.
Mr. Moore?
No.
Mr. Sangha?
I vote yes.
Mr. Virani?
Yes.
Madame Brière?
Oui.
Alors, yes pour 7, nays contre 4, 4.
Thank you, Mr. Clerk. So clause 4 carries. Now we're going on to what is a proposed new clause 5 by Monsieur Thériault in the form of BQ4. So go ahead, Monsieur Thériault, if you want to move it.
Yes, thank you, Madam Chair. The purpose of this amendment is to be preventative. When the Minister came to meet with us, he told us that it was his desire, unequivocally, that the legislation be reviewed in short order so that all the very sensitive aspects, the absence of C7 creates. Now, that includes the whole issue of mental health. C7 does not include mental health in any way, shape or form. So my amendment seeks to remedy that situation such that mental health be studied, and not just mental health. Everything that was created a vacuum by C7, well, that includes neurodegenerative diseases. And we heard witnesses before us who were more than prepared to go deeper into this issue, to delve deeper into this issue, and to say, well, yes, to amend the criminal code C14, we can enact a C7, but then we need to get back to the drawing board so that we can deal with those issues. And I would go so far as to say today that the Cutter and Baudouin decisions, and this is the claim of the Supreme Court of Canada and Mr. Menard, he goes much further in his decision in facts. and includes those who are affected by mental health issues or neurodegenerative issues, and that they should have access to MAID. And the question that I am asking myself is that given that C7 fails to overhaul the legislation entirely, does that mean that automatically, and perhaps this question that I'm asking is directed at the lawyers from the department, but if it's omitted, if it's not specifically mentioned in C7, does that mean that we fall under Article 10 of C14 that states that it's every X or Y number of years? So if it's an amended legislation, in a sense, it's a new legislation. And does that mean that there's a lag of 5 years before it's enforced? So that's what my amendment seeks to avoid, so that we're not, just getting bogged down in these issues of what's the void created by C7 when we had the minister appear before us, and we need to deal with this in short order because C14 already included provisions that as of this very summer, or rather this summer just gone by, would have provided for a more fulsome revision of the legislation. So could someone just respond to my misgivings about that? Because that's why I've tabled this amendment. Some have said, we can't, do this when it's too early. We're waiting for C7. But C7 isn't legislation per se. It's a component of legislation which we call the criminal code. And there's jurisprudence that is telling us that as legislators, we're leaving a whole lot of holes in the legislation that is problematic. And, what if this went back to the Supreme Court and was challenged by it again, and then we are told what to do by the court rather than discussing the whole issue among ourselves as legislators on the front end? Those who have neurodegenerative illnesses and diseases, if they learned that it might take 3, 4, 5 years that a review of the legislation would be finally conducted because that's what's stated in Section 6, well, then of course they'd want it to go to the Supreme Court. So, as I said, the purpose of my amendment is, and even if C7 is enacted, at least we could do this immediately and consecutively. You'll recall that I asked the minister whether we could do this concurrently or consecutively, and the minister said that, it kind of depended, and I found his response a little bit vague and evasive, but that's my purpose for tabling or moving this motion today, quite simply because I didn't get any answers to the questions that I asked, and I just didn't want to take any chances. So that's my motion.
Thank you.
So who'd like to respond to me, please? I'd really like some clear responses. Who'd like to respond to those question marks? I just don't want to be told that it's out of order, my motion.
Thank you, Monsieur Thériault. We have Mr. Maloney next on the speaking list. Thank you, Mr. Maloney. Go ahead.
Not sure Mr. Thériault was looking to me to answer his questions, but nonetheless.
On a point of order, Madam Chair, listen, I asked a question, a contentious question of the lawyers of the department. I have misgivings, and so I want a response to my misgivings before we proceed in any other way. This is absolutely crucial. If the response is, don't worry, Mr. Thériault, C7 in no way will impact what's already provided for in Section 10, well, then the legislation will be able to be revised in a month or in 2 months or when we get back in January. Well, no worries at all if that's the case. But if it's not the case, well, we have a problem. And that's why my amendment is relevant, and that's why I'd like an answer to the questions that I've asked. A legal clarification, please.
If anybody from the department would like to answer Monsieur Thériault's questions.
Oui, merci, Madame la Présidente.
Yes, Madam Chair. Well, it's our understanding. I'm sorry, I cannot hear you, says Mr. Thériault. Can you hear me better now? You can? Good. Okay, so it's our understanding from what the Department of Justice has said that under the previous Bill C-14, there was an obligation for parliamentary review from the fifth year after the legislation comes into effect, and that obligation would be applicable here too. You know, the fact that there's another piece of legislation that amends sections of the criminal code that would in any way affect this obligation in vis-a-vis Bill C-14. So it's our understanding that this is an obligation for one single parliamentary review. It is not an obligation to have a parliamentary review every 5 years. We're talking about one single review that is required. And nothing would suggest that this obligation would in any way be deleted or removed or dropped because of other legislation. Question. Can I ask a follow-up question, please? Here I go. So at some point, I was told that if I moved this amendment on C7, it would only have to do with one review of C7 and not the entirety of the piece of legislation. Is that correct? Response. Well, that's an interesting question that you've posed. I think that the scope of the obligation, well, it depends on the wording you choose as parliamentarians, doesn't it? Now, if there is an obligation under a new bill to review not only what is in the bill itself, but in other legislation that is relevant and germane, well, my answer to you is that I think that that would be permitted. And let me give you a good example. In Bill C-14, a committee had stated that during their slated parliamentary review, they also needed to study palliative care. And yet that wasn't directly provided for in Bill C-14. So as parliamentarians, you can impose an obligation for a review on whatever you want. That's the crux of the matter.
Does that answer your questions, Monsieur Thériault? Good. Mr. Maloney, going back to
J'ai
you.
compris que la santé mentale.
Yes, but I understood that mental health care would not be necessarily excluded in a review of under Article 10 of C-14.
Thank you. Mr. Maloney, go ahead, sir.
Thank you, Madam Chair. Thank you, Mr. Thériault, for introducing this proposed amendment. And I understand where you're coming from. My concerns are on a couple of different levels. But for the pandemic, there would have been a review undertaken already with respect to C-14, as was required by the legislation. It's unfortunate that it wasn't able to go ahead in a timely manner, but we all know the reasons why, and I don't think anybody really takes issue with it too strenuously, at least, I hope. So if to the extent that this amendment is in response to that delay, I think it's unnecessary. On another level, I think it may be a bit overzealous in the sense that if we were to apply a one-year review criteria to every piece of legislation that this committee or other committees passed, that's all we would spend our time doing, is reviewing legislation that had been passed within the last 12 to 18 months, which I think speaks for itself as being unnecessary. So my understanding is that there's going to be the review taking place sometime as soon as perhaps, in fact, likely perhaps to be early in the new year. I think by necessity, and I think we just heard this confirmed, that that will include all aspects of this legislation, including some of the issues, many of the issues, if not all of the issues that we've been talking about during the course of the last 8 meetings. In addition to that, we'll be discussing and reviewing other aspects of the legislation as well, which will necessitate and involve some further widespread consultation. So all of which is to say that I, although I appreciate your amendment and I empathize with your motivation, I think in the circumstances that we're currently in, that it's unnecessary on the one hand, and on the other hand, it may be placing too heavy an obligation on this committee. Thank you, Madam Chair.
Thank you, Mr. Maloney. Mr. Moore, I have you next on the list. Go ahead, sir.
Thank you, Madam Chair, and thank you for Mr. Theriault for moving this amendment. I think it's an interesting amendment. I think it's a timely amendment. It raises a number of concerns that I have, and I do have some questions about the amendment. Mr. Maloney just referenced our committee having to deal with this, but my read of this is that the amendment as proposed by Mr. Theriault says that the application must be undertaken by any committee of the Senate, the House of Commons, or both houses of Parliament that may be designated or established for that purpose. Designated or established. So a similar language to what's used in C14. We are not necessarily, the Justice Committee would not necessarily be the committee tasked with this review. The reason why it's important, I think, to consider this amendment is we're moving at lightning speed on a brand new to Canada area of law. Up until C14, providing assisted dying was strictly prohibited within our criminal code, and this is what's being amended. What was amended with Bill C14. Bill C14 was a response to court decisions, and Bill C14, which was passed by the previous Liberal government, involved a mandatory 5-year review. It used similar language to this amendment, was not prescriptive as to which, whether it would be a review conducted by a joint committee of both houses, a specified committee within the House of Commons, or a new committee put together for the purpose of the review. But as we know, that review that was to take place this past summer did not take place. Could a review have taken place in some capacity? Well, we were able to do a lot of things this summer. We all recognize the challenges faced with COVID. But here's why it's important. The review, the minister has signaled a number of topics for the review. Minors, persons whose underlying issue is mental health only and not some other disability or injury. Advanced directives. And you'd think that a review like that would inform new legislation. And unfortunately, with the decision in Quebec, that was not appealed to the Quebec Court of Appeal, was not appealed to the Supreme Court of Canada. The position that I would take is that when you have new legislation, part of the role, we have a joint, in Canada, we have a Minister of Justice and Attorney General. The Minister of Justice is responsible for justice legislation like what we have before us today. But the Attorney General has a distinct responsibility as well. The Attorney General's job amongst other things, is to defend within the court system Government of Canada legislation. The Attorney General did not do that. In fact, at the first opportunity, so you have a brand new shiny bill created with a majority Liberal government called C-14. It provides for medical assistance in dying. It has a number of safeguards. It includes a requirement that one's death must be reasonably foreseeable. Well, the court decision struck down that aspect and said, no, a person's death does not have to be reasonably foreseeable. So instead of seeking clarification, instead of defending the legislation, there's a reason why at the limited committee meetings we heard overwhelmingly from the persons with disability community about their concerns with C7. Because many of those people that we heard from, including individuals that appear before this committee, would not have been eligible for assisted dying under C-14, but now may be eligible or would be eligible under C-7. They're concerned with the message that sends to their community. So this is why this provision is important. The government did not initiate. The government still hasn't initiated. Now, provincial legislatures are up and running. The House of Commons is up and running. We're having this committee here today. People are used to meeting virtually. All of our witnesses at this committee on this bill and future bill are going to be, by and large, my understanding, appearing remotely. We heard from physicians, we heard from people in the disability community, we heard from MAID assessors, we've heard from MAID providers, we've heard from psychiatrists, we've heard from a broad spectrum of Canadians, and other parliamentary committees are doing the exact same thing, even today, are doing the same type of thing that we're doing. So when I hear about this legislative responsibility that we had in C-14 to have a committee look at the state of assisted dying in Canada 5 years after the passage of C-14. It was supposed to be completed already. It hasn't even started. And now we hear, well, maybe it'll start in January. Some of the things that were supposed to be studied in this review are things that right now we're dealing with on C7, advanced directives. The Turchon decision did not deal with advanced directives, but this legislation has advanced directives in it. The Turchon decision did not say that the 10-day reflection period was unconstitutional. It didn't say that having two witnesses, two doctors, a doctor that specializes in the ailment that the person has, it didn't say that any of those, it didn't raise any of those things, didn't say there's anything wrong with them. Yet those changes are included in C7. Now, we could debate whether we agree with or don't agree with those changes, but what is not subject to debate is that those changes were necessary to respond to the Quebec court decision. They simply were not. They were added into this legislation. Now, Parliament, in its wisdom, in passing C-14, said, after 5 years, we're going to study this. Implicit in that is that study would inform future legislation. Instead, 5 years later, we have new legislation that raises tremendous concerns across Canada. Legislation, I certainly went into this study with an open mind to look into C7, and we heard from witnesses, and the more I heard, the more concerns I have. When we have palliative care doctors saying there's no protection for conscience rights, that there's no protection for people who have MAID suggested to them, maybe repeatedly, when it's not something that they're considering. From the disability community saying that this makes us a second-class citizen, that this is a nightmare scenario. Their words, not mine. Those are the words that we heard from enabling accessibility. from other groups, Canadians with disabilities. We heard from Roger Foley, a person who took the time to appear before this committee and make the case, because, very selfless action on his part, because he's doing this for people that are going to be in his situation in the future. We have to listen to those voices. And that's why, the 5-year thing didn't work, because here we are. The government to this point, we know this summer there was issues, but here we are. November's almost over. We're coming into December. There's no reason that this study couldn't have started. The reason it hasn't started is because maybe they don't want to hear what it has to say before they pass more legislation, like C7. So in a vacuum where we did not have the benefit of this study, we have C7. Now, how many days did we spend studying C7? 4. And this relates directly to the amendment being proposed by Mr. Theriault. 4 days to study something that profoundly changes the law in our country. Profoundly, completely different. But if should be Bill C7 become law, the law when it comes to assisted dying in Canada will be profoundly different than it is today. That's without any debate. There's no argument on that this what we're doing right now is going to have a profound impact. I would have liked, as a parliamentarian, I did not participate in the debate or the votes on Bill C-14. I would have liked, though, to have had the benefit of that parliamentary study, whether it was the Justice Committee or a hybrid committee or a committee of the Senate and the House. I would have liked to have had the benefit of a robust study, hearing from a variety of witnesses that could have informed us in our deliberations now. So without the benefit of that, we have this committee. And in this committee, we took 4 days. Now, the first day was taken up by the ministers who, of course, and this isn't a partisan thing, because, when we were in government, we enthusiastically support our bills. Well, the ministers enthusiastically support their legislation. Of course they do. I haven't seen a sincere, really sincere effort to reach across the aisle and say, we recognize the diversity of our country. We recognize there's 338 elected parliamentarians that are all here to do a job. We recognize around the table, we're all equals around the table, and that no one party, mine included, has a lock on good ideas. Every party represented here today, there's some aspects of, if we're really honest with ourselves, there may be things of value each of us can bring to the table. We've moved and we've talked about 10 conservative amendments. None of our amendments would have been earth-shattering. Some of them, in fact, just put back safeguards that the Liberal government itself saw fit to put into Bill C-14. So what I want to be abundantly clear on is, without even the benefit of this parliamentary review that's in C-14, this government, the same government that passed C-14, the Liberal government again, is peeling away the safeguards that they included in C-14. Now, I know some people might say, well, we see they don't work. How do you arrive at that conclusion without the benefit of the parliamentary study that you saw fit? I know people like to cite different groups. We can all do that. And I think when we all do that, it should inform our decision making. It doesn't mean any one group is 100% right. And I don't believe any one group that we heard in our limited testimony is 100% wrong. And when I see frankly, when I see the receptiveness of the government to some of the very fair, well thought out, and appropriate amendments that conservatives raised, I hope it's not leading to the conclusion they feel that they, that they know it all and they have a lock on good ideas. I'm willing to say that some of the amendments from other parties I agree with, and I happen to agree with this one. I agree with BQ4 because I hope we're not banging our head against the wall when, well, if the government ignored a 5-year study, well, maybe they'll ignore a 1-year study. If they ignored one that was supposed to take place after 5 years, maybe they'll ignore this one that's supposed to take place after 12 months. I hope that isn't the case. I hope that we can send the message that if there's any area of law that deserves safeguards, deserves a really deliberate look at the implications and the in the application of the law, then it's assisted dying. There's no question on that. It's literally life or death. And it may not be the group that's here today. It may be some future parliamentarians, but I want future parliamentarians to be informed by a robust study before they make new decisions and new amendments. Frankly, those of us on the Justice Committee right now did not have the benefit of that type of study. I refuse to accept that the 4 days that we spent of witness testimony, the first day being the ministers, was a robust study of this bill. It wasn't. This bill, the people that appeared before it, how about the people that didn't get to appear? How about the Canadians that didn't get to appear? They didn't have their say. I know they've been sending in some of them briefs that help to inform us as parliamentarians, but we need to have, we can't have the thinking that one group knows best, one party knows best, and we're not going to properly study things before making legislation. That cuts across party lines. It doesn't benefit any of us, and it does a disservice to Canadians if we think we can do up a first draft of legislation and put a stamp on it and say, you know what, that's good to go. It doesn't really matter what people have to say about it. Frankly, that's what we saw this time. I think 4 days was clearly not enough. We've been saying that all along. So now we're studying clause by clause, but we're studying clause by clause with the limited benefit of the limited testimony we've heard. But the testimony we have heard leads me to the conclusion that the safeguards that were in C-14 should have stayed in Bill C-7, shouldn't have been stripped out. That further expansion of Made in Canada should have followed only after a robust parliamentary study, as was contemplated in C-14, and that we as parliamentarians have an obligation to put in those safeguards that include review of the legislation so that we can protect the people. I believe everyone around the table wants to protect vulnerable Canadians. We may all have a different approach to that, but including a parliamentary review can do, there's no harm in that. Absolutely. So I support this amendment. I believe it sends the right message, first off, but I think it also will help inform future parliamentarians on future legislation dealing with MAID, which this group, this current Justice Committee here, November of 2020, we did not have the benefit of this type of review. I hope future parliamentarians do have the benefit of this type of review, and that is why I am pleased to support BQ4. Thank you, Madam Chair.
Thank you very much for that, Mr. Moore. Mr. Garrison, I have you next. Go ahead, sir.
Thank you very much, Madam Chair. During the discussion of amendments, I have limited my interventions because I think it's important that we deal with Bill C-7 so that the safeguards that Bill C-7 provides for the second track would be in place in the province of Quebec if the court decision does go ahead. I also think it's important because in my riding, I know that there's much unnecessary suffering caused by the 10-day waiting period and by the inability to waive final consent. That said, I want to speak to this amendment because I share the concern that we need to do the broader study of medical assistance in dying, not just Bill C-7. That's why I put a motion on the order paper earlier this fall calling for the creation of a special committee and expanding the mandate of that committee to include the question of whether or not safeguards for vulnerable people are in fact adequate in medical assistance in dying. It was my hope that the House leaders could reach agreement to establish such a committee. They have not done so. So I hope that in our next session of committee business, we can consider whether this committee can go ahead and begin that review and establish a time frame for that review. So I think the unfortunate consequence, unintended surely, of Mr. Theriault's amendment, is that it would provide the implication that we ought to delay this general review for another year. I think that would be quite unfortunate, or that we have two simultaneous reviews going on. So for those reasons, as much as I want this general review to start, I am not in favor of Mr. Theriault's amendment.
Thank you, Mr. Garrison. Monsieur Theriault, I believe your hand is raised if you'd like to respond to the comments made.
Yes, I would indeed. Yes, we did hold 4 meetings. 4 meetings? Well, that's because there was 2 extensions given by the court. Now, if there were 2 extensions given by the court, it's because after the election we didn't get up and running quickly enough. And we didn't hit the ground running. The government decided to amend the provisions of MAID under the two, the word escapes me. Anyway, under the 2 systems, that is natural death and safeguards, that's the word I was looking for, and foreseeable. And in order to respond to the order handed down by the court. Now, and this is the question that I'd asked our legal experts, Mr. Garrison just said that we would be forced by adopting this amendment to have 2 general reviews that may be simultaneous in nature. I don't think so. All that this amendment says is that Mr. Garrison wants a special committee, and I want one too. We want a special committee, and we are reiterating in the motion before us that in the 12 months following, that is January, February, March, because there was royal assent, there'll be royal assent in December. So in the 12 months following, there will be a review, etc., etc. And Mr. Garrison referred to this, the MAID. And that's what the provisions of C14 refer to. So I don't think that there's any duplication of the intention. We're just reiterating parliamentarians' attention that this should be done, and that it should be done this year, within a year, and no later, and that it shouldn't take longer than a year, so that we can agree at the end of the day as to what should be added or deleted to the MAID legislation. And C7 indicates that there are so many Canadians and Quebecers that want to discuss this legislation. Now, the first words I uttered when we started this study is that we always needed to be mindful of the fact that whilst we debate, there are Canadians and Quebecers suffering, and all the more so in the midst of a pandemic. These are non-COVID patients, quote unquote, that are being heavily affected by all the upheaval in the healthcare network. So, you know, there was an order handed down by the court, and I think we need to reiterate, well, just as Mr. Garrison said, well, you know, leaders don't necessarily agree, but as a parliamentary committee, we need to reiterate that this is the kind of study that we need. And that's what my amendment posits, that it's not contradictory to C7. It's not, and so therefore, I think it's important that we remind folks of this, and that we send a message to the executive branch that they should stop dragging their feet, they should stop throwing a spanner in the works of parliamentarians, because she shouldn't be acting after the fact when there's orders handed down by the courts or court challenges, because that creates a boomerang effect with orders handed down by the courts because we're not doing our jobs as legislators. And I think that what Quebecers and Canadians expect of us are that we respond to C7 because a third extension would be absolutely egregious and abominable in terms of those who are suffering. And I don't think that we should equivocate in the message that we send through to the executive branch, which should ring loud and clear and unequivocal. And that is why that I am all the more convinced, given that this doesn't deal with the obligation or negate the obligation under C10, but it complements it. It complements that obligation in the sense that it specifies a time frame, and at the same time it sends a clear signal to all those who are waiting to go to court to challenge the legislation what's going on. Remember, there are Canadians and Quebecers that want to challenge the legislation because we're not going far enough, others because we're going too far, and yet we tried to deal with this in 4 days, in the space of 4 days, and we're sending out the message that C7 is a balanced response to the court order, and yet us as parliamentarians, we are delving deeper. We are thinking more about these sensitive issues. We need to demonstrate that to Quebecers and Canadians. That should be our modus operandus when it comes to such sensitive, delicate issues as these with which we are seized here at this committee and have been for a number of hours. So that is my plea to you, and I conclude.
Thank you very much, Monsieur Thériault. I have Mr. Cooper next on the list, and then Madame Finlay. Go ahead, Mr. Cooper.
Great. Thank you, Madam Chair. And I, too, would like to speak in support of the BQ amendment. And let me first say that I agree with Mr. Thériault to the degree he stated that his amendment is not duplicative, that it is complementary, and that it reinforces on the government something the government failed to do when Bill C-14 was passed. Mr. Moore, in his comments, noted that he was not here during the debate on Bill C-14. I was here on the debate on Bill C-14. I was a member of this committee, as were you, Madam Chair. And I can say at the time that the provision in the bill mandating a 5-year review was considered to be a very, very important part of the bill. At the time, we were in uncharted territory. We had a Supreme Court decision in Carter that struck down the blanket criminal prohibition on medical assistance in dying. We were starting certainly from the parameters of Carter, but there was much that was unknown in terms of how to provide for a legislative response that satisfied what the Supreme Court called on Parliament to do, which was to strike a balance between respecting individual autonomy while at the same time protecting vulnerable persons through a carefully monitored and designed system of safeguards. And the process, starting with the Special Joint Committee on Physician-Assisted Dying through to the passage of Bill C-14, was over a period of 6 months, from January of 2016 to the end of June of 2016, in which between the Special Joint Committee and the Justice Committee, we literally heard from, a wide range of witnesses in a process that was, although not perfect, was a marked improvement from the process that we have had with respect to Bill C-7. The purpose of establishing that 5-year review was in recognition that that would provide sufficient time to determine what worked, what didn't, were the safeguards appropriate, were changes needed, and to provide a period in which C-14 could be implemented across Canada. And that, it was certainly, I certainly thought at the time that that would have been the first step, that there would have been a review and then the possibility for amendments to Bill C-14. But none of that happened. We didn't get a review in June of this year. Mr. Maloney made reference to the fact that there is COVID. Well, yes, there was then, there is now. I don't believe that that is an excuse, a legitimate excuse for why a review could not have taken place and should not have taken place. But I would note that the fact is that before COVID, this government decided to preempt that review because Bill C-7 was introduced before COVID. That went considerably well beyond the scope of the Truchon decision and removes, as we have heard about, many important safeguards in Bill C-14. So the idea that somehow COVID got in the way of a parliamentary review just doesn't add up. The attitude of the government was, we know best. We're moving ahead with legislation that fundamentally changes the landscape around the medical assistance in dying regime without undertaking any kind of review. The minister and members of the government bragged about their online consultation that they say informed the drafting of Bill C-7. I would note, Madam Chair, that several witnesses came before our committee today over the very short time we had hearings to indicate, including some who did participate between the online survey and the limited consultations that occurred, I believe, in February, that all of those consultations were with a predetermined outcome. They did not believe that the government was interested in hearing all perspectives, but rather had a specific objective upon which the government wished to legislate on, and was seeking an outcome to validate proceeding in the manner that the government ultimately did with the bill that we have before us, namely Bill C-7. I would also note that in addition to that consultation being a predetermined in terms of its outcome or biased, as evidenced by a number of witnesses who stated that the online consultation disadvantaged many vulnerable and marginalized Canadians, those who don't have access to the internet, those who have visual or mobility or cognitive impairments, their views, their perspectives were ignored, certainly made more difficult by what I think was really an insensitive process. People living in remote and northern communities, where were they during the online consultation? And so now we have this very unacceptable situation where we have a very bad piece of legislation that has been repudiated by every national disabilities rights organization in Canada, by over 1,000 physicians, and we don't have a review. And what is needed is that comprehensive review. It should have happened before Bill C-7. It hasn't happened, but with this particular amendment, it would reinforce the need for that to happen, and for that to happen immediately so that we can have true and meaningful consultation from all segments of Canadian society impacted by medical assistance in dying, by all of those groups, and to do it in a comprehensive way, and to hear from the voices that went unheard as this government has sought to ram through Bill C-7. Voices that I happened to be at a press conference this morning where there were many voices, including Indigenous voices, that have gone unheard in the 4 meetings that we have had to hear from witnesses. So, I've said it before, and I'll say it again, it need not have been this way. It shouldn't have been this way. It is this way because of what I would submit it has been a reckless approach on the part of the government, and that at the very least this amendment underscores what should have happened, what absolutely needs to happen, and that is for a review, not in 5 years from now, but in a manner that is as expeditious as possible, and certainly a 1-year time frame is more than reasonable. Thank you, Madam Chair.
Thank you, Mr. Cooper. Now going to Madame Findlay, who is next on the list. Go ahead, Madame.
Thank you, Madam Chair. I'll be fairly brief. I see the time we're running up against here. Basically, I feel reviews are necessary. As I referred to the other day, very significant, life-altering, pan-Canadian legislation that we're discussing. Speaking, these are issues where a few short years ago, these procedures weren't even allowed. So we went into a whole new territory. And now with the changes from C-14, excuse me, which I was not in Parliament to debate, but with the changes from that, many of what I would have thought, and obviously my side of the table believed, were reasonable safeguards, have been rejected by others here on the committee and by their parties. So I don't quite understand, to be honest, my colleague, Mr. Garrison's comments that this goes against what he is hoping for. And maybe I didn't understand clearly what my friend had to say, but the amendment that I see it, that has been put forward by Monsieur Thériault, speaks of within 12 months. It doesn't say after 12 months. It says, or at 12 months. It says within 12 months. And it also says that it will be undertaken by any committee of the Senate, the House of Commons, or both houses of Parliament that may be designated or established for that purpose. So as I read this reasonable amendment, which I support, what is being sought here is a mandated review within 12 months that may be undertaken by this committee, may be undertaken by a special committee. But the point here is there's a mandate to make sure it happens. There are those, and again, I thought Mr. Theriault's comments were very good, that this is a complementary, it complements the legislation that we are clearly moving towards passing here. It sends a clear signal to those wondering on both sides of all these arguments where we're going. It sends a clear signal to those who may be thinking of court challenges or who may just be feeling that this changes their environment and their worldview. That we as legislators take this seriously. 4 days on such significant and important legislation is not sufficient, I believe. The rest of the committee did not agree. They wanted this through quickly. I think we should have heard from more witnesses. I don't know what's going to happen in the Senate, but to me, there's nothing here that is stopping what Mr. Garrison was speaking to, which is to get on with this, get on with a review that should have happened, a review that was not pursued by the Liberal government, even though they were mandated to do it. So that I still don't understand. And we sit here with legislation which goes way beyond the Truchon decision. We're making decisions as legislators, it seems to me, depending on which healthcare professionals you choose to listen to, and whether you choose to listen to the organizations for persons with disabilities or not. This is very significant legislation. I don't think it leads to every piece of legislation having a review clause in it at all. This is legislation that is in its own category, in my view, in terms of significance. And this amendment simply puts us all on notice as legislators and the government that there's a process that would require a careful and proper and more thorough and more well-informed look at legislation that is so significant that we are making changes to the criminal law of Canada. We are making changes to the provision of health care. We are making changes to the provision of palliative care. This committee has chosen not to put in safeguards for conscience rights of physicians. We've heard from physicians that say that they will have to leave their chosen profession if there are no such safeguards. This would be an opportunity. Earlier amendment was not passed, but this would be the opportunity to look at the lived experience and dying experience of people who are within this system, who choose to end their lives this way, who change their minds, who choose not to go this path. It gives us an opportunity to look at what supports are in place, what true options are in place for people facing these tough decisions, and for their families, quite frankly, because there's more than just the individual affected. And I think it's a very reasonable amendment that would bring forward. I just don't trust the fact, to be perfectly honest, that when a review was already mandated and the government chose not to do it, that unless we have it in the legislation, I'm not confident that just asking this committee to look at it will work. I think the government has shown It is prepared to put forward legislation in this area that goes far beyond court decisions, that goes far beyond the directions of the court to date. And therefore, this review is absolutely necessary. And I think Canadians would expect no less of us. Thank you.
Thank you, Madame Findlay. I have Mr. Lewis next. Go ahead, sir.
Thank you, Madam Chair, and I will be brief. But I just wanted to make reference. I know earlier on in the debate specific to this amendment, Mr. Maloney made reference to the fact that Bill C-14, the review didn't get done with that because of the pandemic, and I respect that. I respect that. However, I have to say, Madam Chair, that so I watch Sunday football, and I watch referees review calls on the field all the time during the pandemic. I watched hockey. I watched referees review calls all the time during the pandemic. When I was a firefighter, we reviewed the on-scene, the actions of the on-scenes after incidents all the time. And I'm sure it still happens during the pandemic. I review my bank statement during the pandemic. So I would just suggest for a moment, Madam Speaker, that it's not because of the pandemic this review did not get done. Let's call a spade here. First of all, it's because the government decided to prorogue government. So that's really why it didn't. But my point, Madam Speaker, is this. If we talk about sports and we talk about my bank statement as two examples, and today during the pandemic, these reviews are still being done, is Bill C-7 and life and death decisions not more important than sports in my bank statement? Absolutely it is. And for the very fact that Mr. Thériault has brought forward this, I believe it to be a very, very great amendment. At least it gives us one more safeguard for this committee to look back on, review. Perhaps some of us won't be here in the next committee, and it gives that next level of a safeguard, because quite frankly, C-14 didn't get reviewed. I think it's vital, and I think it's due diligence on our behalf to see that going forward. So thank you very much, Madam Chair. I appreciate that.
Thank you, Mr. Lewis. So I will call the question now on BQ4. Mr. Clerk, if you can record the division.
Mr. Cooper?
In support.
Ms. Findlay?
I am in favor of this amendment.
Monsieur Thériault?
Je suis pour.
Mr. Garrison?
Against.
Mr. Kellaway?
Against.
Mr. Lewis?
I am in support.
Mr. Maloney?
I am against.
Mr. Moore?
Support.
Mr. Sangha?
Against.
Mr. Virani?
Against.
Et puis Madame Brière?
Contre.
Yeas pour 5, nays contre 6.
Thank you, Mr. Clerk. So this amendment is defeated. Now, going on to the preamble. So I call the question, shall the preamble carry?
Mr. Cooper?
No.
Ms. Findlay?
No.
Monsieur Thériault?
Oui.
Mr. Garrison?
Yes.
Mr. Kellaway?
Yes.
Mr. Lewis?
No.
Mr. Maloney?
Yes.
Mr. Moore?
No.
Mr. Sangha?
Yes.
Mr. Virani?
Yes.
Et puis Madame Brière?
Oui.
No.
Yeas pour 7, 7. Nays contre 4, 4.
Thank you, Mr. Clerk. So the preamble carries. Shall the title carry?
No.
On division.
Oh, on division, I guess. Yeah. On division, yeah.
Thank you. That's what I was trying to get your attention for.
Sorry, Madam
earlier.
Chair. I was.
No, you're fine. So the title carries on division. Shall the bill as amended carry? On division?
No.
Recorded.
Okay, Mr. Clerk.
Mr. Cooper?
No.
I can't hear the clerk. Has he called my name?
Absolutely. Miss Finlay?
I hear you now. No.
Monsieur Thériault?
Oui.
Monsieur, oui. Mr. Garrison?
Yes.
Mr. Calloway?
Yes.
Mr. Lewis?
No.
Mr. Maloney?
Yes.
Mr. Moore?
No.
Mr. Sangha?
Yes.
Mr. Virani?
Yes.
Madame Brière?
Oui.
Donc, yeas pour 7, 7, et nays contre 4, 4.
So the bill as amended carries. Shall I report the bill as amended to the House? Yeah. On division?
On division.
On division, thank you. And shall the committee order a reprint of the bill as amended for the use of the House at report stage? On division? Okay. Thank you very much. And just very quickly, for members.
Madam Chair, after C7, I will be replacing Mr. Thériault. So I'd like us to discuss the motion, the notice of which was given on the 3rd of November. Shall it please you?
Thank you, Monsieur Fortin. And I was just about to talk about what's going to happen in the next couple of meetings. So I am seeking consent of the committee to on Thursday to have the first half of the meeting for committee business, specifically with respect to C6. And I seek the consent of the committee to be a little proactive and invite the ministers responsible for C6 for the second hour of the meeting on Thursday. To allow for them to speak to Bill C6 and answer the members' questions.
Madam Chair, why not study my motion in the first half of the meeting and then deal with C6 thereafter?
So thank you, Monsieur Fortin. So as it will be committee business, you're welcome to, members are welcome to discuss whatever needs to be discussed during that committee business. Obviously, we need to start with C6 as well. So you know, like at the next meeting. Mr. Virani?
Madame la Présidente, je m'excuse. Je voudrais simplement, comme point...
Apologies, Madam Chair. It's point of order. Next chance we get, it may not be today. It's already 1:15. At the next meeting, we should start with the study of the motion I gave you notice for on November 3. The interpreter regrets, but Mr. Fortin, it's hard to hear.
Monsieur Fortin, I don't, Monsieur Fortin, Monsieur Fortin, my apologies, sir. I don't think you're wearing a headset, and I'm having difficulty with the interpretation, and je m'excuse.
Apologies, Mr. Fortin. I can't hear you in French, so I need the interpretation. I apologize, says Mr. Fortin. Can you hear me better, Madam Speaker?
Vous
m'entendez? OK, good. Alors, désolé, j'avais...
Apologies, you're right. I was not wearing the headset. My mistake, says Mr. Fortin. So as I was saying, and apologies once again, I know that there's sort of a race going on because each of us wants to be the first out of the gate to speak to a motion. So I would like you to make note of that whenever we can. I understand that today's meeting is coming to an end. It's 1:15, even 1:16. But as soon as we get the chance, Thursday, from the get-go, we are seized with the motion I gave you notice of on November 3rd last. Are we in agreement? Or would you like me to go about this another way?
My apologies, but the question that I had asked the committee members before you had spoken was specifically about seeking the committee's consent to invite the two ministers that are responsible for C6 for the second.
There's no consent.
There's no consent. Okay. Mr. Virani, I have you next on the speaking list on this.
So, Madam Speaker, given the time and the patience that we've all observed through 4 hours, 4 meetings of clause by clause, I would move that the committee do now adjourn.
So we'll call the question. Mr. Clerk?
Mr. Cooper?
In support.
Ms. Findlay?
I agree. I support.
Monsieur Fortin?
Je suis d'accord.
Mr. Garrison?
Agreed.
Mr. Kellaway?
Yes.
Mr. Lewis?
I'm in support.
Mr. Maloney?
I'm in support as well.
Mr. Moore?
Of course, it's 2:18 in Atlanta.
Mr. Sanga?
Support.
Mr. Sanga?
Support.
Mr. Virani?
I support.
Madame Brière?
Je suis d'accord.
Alors, Madame la Présidente, il semble que les membres en aient assez.
Madam Chair, it seems that the members are done for today. 11-4, 0 against.
Mr. Clerk, and now that I have my gavel back, meeting is adjourned.